Hello, my name is Joshua Gilliland, blogger for Bowtie Law. Thank you for joining us today for the Legal Geeks educational series. At the Legal Geeks, we enjoy all things geeky and the law, and our educational series explores different cases, analyzing different areas of civil procedure, evidence, and today we are exploring undue burden as it pertains to electronic discovery. So, undue burden. First off, let's look at the rules for a definition. Pursuant to Federal Rule of Civil Procedure Rule 26B2B, a court may limit discovery of ESI, electronically stored information, that is not reasonably accessible because of undue burden or cost. Great rule statement. Well, how's it applied? Well, for the last 6 years, many attorneys have gotten in trouble in trying to argue undue burden with electronic discovery. Many attorneys, not all, but many have gone into court and stated, Your Honor, we should not have to produce this electronically stored information because it's expensive. Period. No explanation that follows. And this can cause problems for a court because they need to understand what the costs are. Well, let's take a quick look at a case where this happened. In this case, the requesting party brought a motion to compel the producing party to produce ESI in data file format. This was stated in their initial request that ESI should be produced in native file format. The producing party resisted and fought, and their sole argument was, Your Honor, producing a native file is expensive. Period. Well, the court did quick analysis looking back to the Zubalake case. And in Zubalake, one of the first major big eDiscovery cases, the issue of accessibility turns largely on the media on which the ESI is stored. This is the sort of thing you need to argue. You need to have some affidavits. You need to have something to show why that electronically stored information is not reasonably accessible. Well, in this case, the court said, you didn't show us why it's not reasonably accessible. And they denied, the argument from the producing party, and they got into trouble for that. So if your sole argument is it's expensive, you can get into lots of trouble. So what do you need to prove? How should you show it? Well, Judge Fasciola, one of the great judges in electronic discovery, has a wonderful passage from one of his cases pertaining to undue burden, and that is an excruciating but highly educational and useful detail. Wonderful explanation of what you should show. So what does this mean? Well, you need to be able to explain to a court where the ESI is. What kind of media is it on? Are we dealing with a bunch of laptops? Are we dealing with tablet PCs? Are we dealing with cloud servers that are in another state? What are we dealing with in being able for a court to go, all right, that's going to be hard to get to. You need to explain how long it's going to take to get the data. What kind of technology will need to be used to get the data? How much that will all cost? Being able to explain each stage from collection to processing to getting into a review platform so a court can go, all right, it's going to take this many hours at this hourly rate utilizing this type of technology to either restore backup tapes or whatever the case is. If it's going to a server farm that's in another country, all kinds of issues that a court needs to be able to analyze beyond merely stating, Your Honor, eDiscovery is expensive. Because that argument alone doesn't carry the day in any of the cases out there. So if you have this issue, and there are many good undue burden examples, be ready to explain how, in excruciating detail, that ESI is not reasonably accessible because of undue burden and cost. Thank you very much, and tune in again as we discuss other legal issues and all things geek on the Legal Geeks. Thank you all, and have a wonderful day.